Last but not least, congratulations to the students of the environmental law and international private law classes who will be participant in this guest lecture. And thank you once again to Mr. Bagdat Kuzhatov, LLM, PhD. Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you and Allah mercy and blessing. Selamat pagi.
Thank you very much for our day, Bapak Dr. Mahmud Siregar SHMU. We will start to have the class as a guest lecture. We welcome Mr. Bagdat Kuzhatov. Is that the correct pronunciation?
Yes.
Okay, thank you. Our class will start from now and it will be at least at international private law and environment law. Yeah. Thank you very much, and also for everyone here. Thank you. The floor goes to you, sir.
Thank you very much. Assalamu alaikum wa barakatuh. Good morning, dear colleagues. I would say colleagues because mostly in the near future, most of all you students become practicing lawyers. That's why I would say Mr. Dean, Miss Rosmalinda, good morning. I'm very pleased and honored to be your guest lecturer today. And I hope that this guest lecture will be relevant and interesting for students. As Mr. Dean already introduced, I'm a practicing lawyer with extensive experience, both academic and practice in the energy sector. Most of my experience includes representing the government and the private companies in negotiations and the international arbitration on international petroleum contracts. Today, I'm a head of dispute resolution department in state oil company PSA in Kazakhstan. Also a teaching professor in international energy arbitration. Today, I would like to give a guest lecture on the topic of international petroleum contracts, comparative analysis. The topic is still very relevant and interesting, as one commentator has rightly observed that energy sector is a natural incubator for international arbitration disputes. That's why the topic is interesting for lawyers, for students who are practicing or studying now and interested in the energy sector, working for law firms or for government or for oil companies. Taking into account that Indonesia is also one of the most powerful and the big oil producing state. That's why I thought that this topic will be interesting and relevant for students today. First, I would like to briefly introduce you with today's guest lecture structure. The first, I'd like to start as an introduction from the history and the development of the petroleum in different regions, and the rise of transnational oil companies, and the first petroleum contracts which signed between states and oil companies. Also, I would like to talk about more United Nations resolution, then about the nationalization, expropriation matters. Further, I will concentrate on different types of petroleum contracts which in use in different jurisdictions, and the differences between them, as well as the special conditions. Then finally, I will focus on disputes arising from international petroleum contracts. The disputes are commercial disputes, also the investment disputes, in particular arbitrations. I will start the topic, and if you have any questions, you can ask me. Please feel free to ask your question during the guest lecture and after the guest lecture. Thank you very much. Historically, it's not from the only legal perspective, but from the production cycle of petroleum. We normally divide the production phase of petroleum into main three phases. The first phase, which mainly will be topic of today's presentation, will be the upstream sector. Upstream petroleum contracts. What normally upstream mean? When petroleum in use, for example, from the extracting the oil from the subsoil into production, for example, to our petrol, to our cars, or any chemical use for heating, all the process goes through all these three main stages. The stages is the upstream, midstream, then downstream. And the lawyers have to deal with all these three stages of the production cycle of petroleum. It means that we have the upstream contracts, we have the midstream contracts, we have the downstream contracts. Today, we will focus on the upstream contracts. Upstream means is the extracting and the production of the oil from subsoil. Then oil, what we should to transport, yes, in order to the final processing. It means the second stage is the midstream, is the transportation, shipping, through could be pipeline or ships or trains, etc. And it includes trading, marketing, etc. Then the third stage is the downstream stage. What does it mean? Downstream will be the final stage which produced oil will be processed for the final use. It could be refining, for example, which could produce motor fuels or jet fuel or other lubricants. It could be petrochemicals, for example, the special chemicals, commodity, etc. Also, it could be LNG. As we know, liquid natural gas or regasification processing, and which goes to the gas market and use it in our everyday life. In our normal life, lawyers have to deal with all these stages, contracts, relationships between parties, and the dispute arising from these international petroleum contracts. To be more clear for you, I would like to specifically talk about this upstream sector, because international petroleum contracts mostly focused on upstream general about the producing oil. That's why I like to specifically mention about these sub stages of the upstream. What upstream sector includes? It includes exploration phase, drilling development, and the production phase. For every company or state who would like to produce or find the oil in Earth, what they need? They need to check geological prospectivity of the petroleum, seismic studies, and trying to test drilling. This is the exploration stage. If exploration is successful, oil companies will try to develop this oil field. It includes drilling the wells to produce oil. it only not means just drilling the wells. It is a very huge infrastructure. Number of engineering works, construction works, building the production facilities near the drilling wells, because after the producing the oil from subsoil, we need to process and separate the petroleum from water, from other components which we got. That's why it is a big infrastructure project, usually, normally in upstream sector. This is related with this production field. These are sub-stages of upstream sector. Moreover, I would like to explain you in a simple words for your understanding what upstream includes. It includes from starting the drilling exploration well, then in case of successful discovery of oil, we need to appraisal well, then a commercial production, and the companies need to maximize the production from subsoil. It means a plateau, then could be after like many years, it will be decline in oil production. After the producing all of the oil from the field, oil companies need to abandon the field and do liquidation works. This is the main sub-stages of the upstream sector. It is for your clear understanding of the subject. I can show you. I would like to show you this in this slide. Is a typical normal production oil wells. You can see in this slide different offshore platforms producing the oil. As we know, it depends on the oil field. It could be offshore oil field in the sea, ocean, or it could be onshore oil field, which could be produced. It depends on the oil which discovered. This is a general understanding of this upstream sector for your attention. If we look back to the history, the producing oil history, like, you know, went back to early 20th century, which major oil companies started to seeking the oil fields around the world to find the oil fields to produce and sell, because at that time, like centuries ago, as now, oil, petroleum resources was the main source of heating, main source of use for like states defense purposes, for army, you know, for like equipments, for jets, as well as other stuff, as the oil was the main source of fuel around the world. Historically, the development of oil resources and signing first forms of international petroleum contracts came from the Middle East in the mid-20th century. As long as crude oil reserves were primarily concentrated in Middle Eastern states, many of which under British and the West European states protectorates, and the investors were exclusively European and the United States international oil companies. As we know, today we have several international oil companies like investing around the world, as in Indonesia, for example, as in Central Asia or Middle East. The companies like ExxonMobil, companies like Chevron, Shell, etc. These companies actually with hundreds of years history, which who started the production of oil in Middle East. Their early relationships between the states which hosting the companies and the international oil companies were formalized under concession agreements for extracting petroleum reserves. Historically, there are many like examples, but the first concession agreement was awarded to William D. Arce in Persia, it's now Iran, in 1901. It is a first like concession agreement. Just water. If you have any questions about this subject, please feel free to ask. As you students, many of you know this concession type of agreement. It is there are in concession agreements, as you know, there are two parties. Yes? One party is from the petroleum agreements perspective is the state, which owner of the petroleum. The second party is the oil company. It means that state awards a concession agreement to oil company to produce the oil for certain period of time and the certain specific conditions and the obligations. It is like normal explanation of the concession. This usually we divide these international petroleum contracts, the concession agreements and the contractual agreements. It is just general types of petroleum contracts like around the world. I will focus on a bit earlier on each of them. You can discuss a bit later these types. The first is historically international petroleum contracts started from the contractual concession relationships. These early concessions, we say, were drafted in the colonial era, and they resulted from agreements between the rulers of Arab states in the Iran and the international oil companies, which supported by the home states as European states as well as the United States. In this perspective, the concession agreements were in effect signed under the triangular relationship between the host state, which is the owner of the oil, international oil companies, and the home state of the international oil companies. Therefore, concessions protected the international oil companies by the home state. It's like on the one hand. On the other hand, such concessions were kind of, assurance against interference by the home state during the concession period. Like it provided sufficient safeguards for oil companies, excuse me. More like safeguards or more protection for oil companies. The early concession agreements, what different conditions, provisions, but the core features of these concessions are very similar. Since, as I mentioned about that, these early concessions were signed during the colonial era, when the Western states had a protectorate over the Middle East. These concession agreements, usually signed for very long year. For example, I just made for your understanding some comparative, analysis. You can see that the duration of these agreements between the state and the oil companies and under the concession agreements constituted, 60 years, 75 years, 90 years, and it included like kind of large territory for producing the oil, and it had a very generous conditions and terms for oil companies. Mostly like these oil companies came from the Western states under the protection of their home state. Principal features of these early concession agreements was exclusive rights for oil exploration in a large area for long duration with very modest payments, given that the economically underdeveloped situations in the Middle East states and the colonial rule, the concession agreements, were drafted mostly in a generously for the benefit of oil companies rather than states. For example, as I mentioned, very large territory transferred to oil companies for producing the oil, and the very long duration, the absence of provision on the return to state ownership before the expiration of the concession agreement. Just imagine, a state provided the territory for 90, 70, 60 years to oil companies, without the obligation to return back this territory to the home state. Oil companies can use these oil fields, whatever, like oil producing purposes, and keeping this territory, for around 60, 70 years. It is, it's in nowadays, it is difficult to imagine. But at that time, like 100 years ago, it was a usual, normal situation for relationships between states and the oil companies. And, there was a very modest, very simple payments from the oil companies to states because, as I mentioned, it was a colonial era, and for producing just oil companies paid very small, modest taxes and the payments to states, and they mostly, just produced the oil and the salt and having a very significant profits from this oil. Then what happened historically? Historically, since that concession agreements provided the oil companies significant profits, they produced like significant volume of oil from the host states, then just selling, getting significant profit for them and for their home states, for European states and for United States. But the situation was changed after the creation of the United Nations, after the establishment of United Nations, General Assembly of United Nations adopted 4 main resolutions regarding these oil fields. What it means. The adoption of resolutions actually changed the whole situation around the oil producing states. The first resolution of the United Nations General Assembly was 1952. It's named Integrated Economic Development and the Commercial Agreements. Then it was in January, in December the same year, in 1952, we had another resolution on right to exploit freely natural wells and the natural resources. Then in 1960, after the 8 years ago, later the General Assembly adopted another resolution, concerted action for the economic development of the economically less developed countries. Then in 1962, it was adopted the main resolution on permanent sovereignty over natural resources. This was the shifting point for participants of the upstream sector, for oil companies and for states. This resolution actually, in order to be more focused, the 1962 resolution was as I mentioned, was a shifting point for relationships between oil companies and states. The resolution focused on firstly the promotion and the financing of the economic development in underdeveloped countries. Secondly, with the right of peoples to self-determination in the international covenants on human rights. Also, this resolution provided the states and the international organizations that shall strictly respect the sovereignty of peoples, nations over the natural wealth and resources in accordance with the Charter of the United Nations and the principles contained in the resolution. These principles are related to the exploration, development of the natural resources, and the right of the states to nationalize oil fields, and to have a more sharing of profits and the other related issues. As I mentioned, before these resolutions, the early concession agreements had a kind of, a very one-sided conditions for the benefit of oil companies. Then the main aim of this resolution was the change of situation. Producing oil shall not be just used for the benefit of oil companies. It should serve for the benefit of the nation, for the people of this country. This was the main focus of the resolution. What happened after this resolution? It started the process of decolonization around the Middle East, around other countries, whole political change around the world. Decolonization initially provided the political independence. Also, it helped to have economic independence for states, who have a very significant wealth of natural resources. Later, a decade later, in 1974, the United Nations General Assembly adopted another resolution. This resolution is a declaration on the establishment of the new international economic order. This declaration changed the whole political situation and the relationships between oil companies and states. The declaration set a new principle of relations between the development states and the developing countries. It asserted, it's a very important point, that each state is entitled to exercise effective control over natural resources, the exploitation which means and suitable to its own situation, including the right to nationalize, transfer of ownership to its nationals, the right being expression of the full permanent sovereignty of the state. after the adoption of these resolutions, the international law itself is, changed because before, as we say in concession agreements, concession agreements is mostly, regulated by the terms and the conditions which declared by the oil companies. Then after these resolutions was started the new era of relations. The first it was is founding a organization of the there are some questions in chat. I see. I will give the response after the lecture, after the presentation, when I finish the main points. I will give my response.
Okay, Bagdat, thank you.
Thank you very much. Asking very interesting questions. Can I ask, here is the students from a bachelor or
Bachelor.
okay, bachelor. Okay.
Yeah.
Which course? I mean, which year?
Third year. Edward? Also the third year. Yes.
Oh, okay, good. I think that whole presentation is understandable for you, which I'm talking now. If you have like some difficulty in grasping the information, please let me know. I'm happy to have a feedback from student side saying that please speak more slowly or clearly. If you have any comments, please let me know. The whole situation in political arena is changed. That oil producing states is went together to started founding different organizations against these international oil companies because the oil companies were very powerful at that time. They can had a very generous concession agreements with these states and had a significant profits from producing the oil on the one hand. On the other hand, the states which actual owner of the oil got that just a small, very modest payments from this producing oil. That's why the states producing oil got together, to defend their interests and the position against the oil companies. After this United Nations resolutions, there were there was a wave of nationalization in Middle East, nationalization of the oil and the gas assets by governments. We have several examples in Libya, in Saudi Arabia, in Iraq, in other states of the Middle East. Then, after these UN resolutions, what states did? States said, at the beginning of the relations, contractual relations between the states and oil companies, the states said, yes, we were like just underdeveloped, less developed states. We did not know the terms and conditions of these oil contracts, petroleum contracts. But it is now changed, United Nations resolutions recognizing the states and the people's right over the natural resources, that states and their people have to have a substantial benefit from the producing oil, because the oil ultimately is the ownership of the state, the people. That's why we need to get a more profit. More profit than you. That's why states said we have to change our contract. The contract which we now have, it's not acceptable for us. We need to get more benefit from the producing oil. That's why the whole situation brought oil companies and the states to revise these early signed contracts, concession agreements. And it brought to signing other new types of contracts, not just concession which we had. What is the difference of the new type of concession agreements? Generally, we had most of the states accepted two types of contracts. First is a modernized concession. The second type is a production sharing agreement, service agreement, and etc. Before I demonstrated the main conditions of the early concession agreements, which are a large arrear, it's a very long period. But after this United Nations resolutions, the situation changed, and the states said to oil companies, the arrear of concession has to be limited. We will not give you very large territory. You have to limited number of sections, fields, which divided into specific zone or for production of wells, oil. And the duration of the petroleum contracts also sharply reduced. It's not 60, 70 years contracts. It's a much reduced, just 10 years, 15 years, 20 years contracts for oil companies. Also, the government has the right control the decisions made by the oil companies, and trying to participate in a management of the producing oil fields. Sometimes the states are a direct participation in oil fields, like through creating their own state companies and having a joint venture with these international oil companies. And the states requested, not just requested, required the oil companies to give a more significant profits to states, to pay taxes, to pay other payments to state budget, like bonuses, other several types of payments. According to our first today's lecture structure, I mostly generally tried to cover this historical part of the international petroleum contracts, like background. Then now I will move to the second part, is types of petroleum contracts. Then we have.
Okay, before we move to the next topic, would you like to take a break for 5 minutes?
Yes, it would be good. 5 minutes break and come back to continue.
Yes, sure, sir. Thank you, Bagdat. So for classes, we have 5 minutes rest, just for a while. You can go to the toilet or break. Yeah.
Thank you.
Thank you, Bagdat.
pengkajian tentang apa ya, konsesi itu di negara konsesinya tentang kerjaan di administrasi waktu itu tadi ya udah yang mudah kita pelajari sih dari suatu belajar jadi apa sih kenal itu ya habis kenalan dulu cepat ada tanya
you tadi kan Indonesia kan, nah itu kan jadi landasan hukum secara modern tentang perjanjian kontrak secara internasional. Cuma dalam hal ini perjanjian kontraknya itu ya dalam batas petroleum contract, maksudnya ini apa? Enggak
Bagdat, are you here?
Yes, yes.
Shall we start? 5 minutes, eyes up.
Sure.
Okay. For the class, we will start our class again. Then please give, if you have a question, you can chat in the chat room, or if we have time, then if you want to, that some of us would like to practice our English in the academic manner. So please welcome us, yeah, Bagdat, to practice our English and discuss with each other.
Okay. I can continue the presentation and to move to the second part now.
Sure, Bagdat, you can do it.
Thank you. I hope that for students this topic is understandable and clear. I'm trying to give this lecture very in a simple words, simple explanation without very specific details or like kind of legal language. I'm trying to use very simple language and trying to be more understandable to students. The interesting is point which the part which we are now moving is different types of the petroleum contracts. The difference from like other fields or other international law, the petroleum contracts like is systematized, have a like number of standard contracts which could be used around the world and adapted under the national legislation, domestic legislation. As I said, these concession agreements, which I focused on, this contract concession agreement was adaptable, for around the world. Each state can use this contract, and adapt under the national legislation. It was a standard contract. After this change of the whole political economic situation after the United Nations resolutions, like states and the oil companies invented other types of petroleum contracts, which also were like standard contract around which used it around the world and adapted under the domestic legislation. One of the main contract type was the production sharing agreement. Very interestingly, this contract was first time concluded in Indonesia, actually 1966, and was proposed by the Indonesian government, because as you know, Indonesia as well is the main oil producing, one of the main oil producing states. Indonesia government proposed, say, concession agreement, which standard agreement used in Middle East or in Indonesia, is not acceptable for us. We need to get more profit, more payment to government budget. That's why we propose this production sharing agreement as a standard contract, standard relations with oil companies. Now is the production sharing agreement is like successfully used contract around the world with some advantages and the disadvantages, of course. the main elements of the production sharing agreement. Actually, my organization, which I'm working for, like state oil companies, the name is PSA, the Production Agreement Company. Because in Kazakhstan, it's also very common type of contract, this type of major oil and gas fields. I'm actually the specialist and expert on this type of the contract because I'm my experience and knowledge mostly focused on the production sharing agreement conditions, terms, and the disputes arising from these contracts. This type of contract, it's totally different from the concession agreement, which we before discussed. Here is in production sharing, the hosting state, oil producing state, said to oil companies, we would like to participate in producing the oil. What it means, our state oil company will be together with you under the contract, and we will share all produced oil between us, between oil companies and between the state oil company. This is a very simple explanation of the term of the production sharing agreement. The direct participation of the host state is usually carried through the joint venture, and the point is entire risk of exploration work is assigned to the contractor companies, the oil companies, which will not be reimbursed these costs if the oil discovery is not successful. In case of commercial production, like a successful oil discovery, the field will be developed by the oil companies, but the production will be shared between oil companies and the state. Of course, the oil companies fully finances all the exploration works, development works, and the other infrastructure, drilling the wells. All the costs will be financed by the oil companies, but the production will be divided between state and oil company. There are two main elements of the oil production sharing agreement is the cost oil, the first element. The second element is the profit oil. What it means? Cost oil means the compensation of cost from the produced oil. Just simple explanation. Oil company finances their money to produce the oil. What kind of costs will be? Will be the drilling the wells, producing the oil, for processing, first initial processing of oil, for separation of the oil from water, from soil, etc. All these costs, name it is a cost oil. International oil companies first invest the money to produce this oil. Then it takes could take a number of years, like 3 years, 5 years, because the first stage will be the exploration phases, because you cannot get oil, directly, saying that drilling the wells and they're getting the oil. It does not work like this. You have to first, as explained in a production cycle, you have to explore, assess the oil field. All of these costs are called the cost oil. Then, when the oil started producing, the oil company will reimburse their costs under the contract. These costs, name it as a cost oil. Then it depends on the contract conditions, but usually parties like accept saying that, for example, from the whole produced oil quarterly, like for 3 months, the whole volume of the oil, like 60% of the oil, will be accepted as cost oil for reimbursement of their previous investment. And the oil companies take this amount, take this volume, like 60% as the cost oil for reimbursement purposes. As a 40% will be shared between the state and the oil companies. It is the second part which remaining after the cost oil. It called the profit oil. It's the second element of the production sharing agreement. This profit oil, it also depends on the conditions of the contract, but usually divided, like most part of the volume goes to the state. State is the main taker of the oil from the profit share. It's from the second element. This is like main two elements of the cost oil and the profit oil part. Of course, the oil companies have to pay taxes and other payments to the state budget. And as I mentioned, is the main elements of the production sharing agreement. Then at that time, there were like two main types of contracts which we had. It's the concession agreements and the PSA agreements, which states mostly use it around the world. Of course, there are totally like really big difference between the concession agreement and the production sharing agreement. In concession agreement, states mostly gets profit through tax or royalty or other payments, not by physical produced oil. In production sharing agreement, the main difference from concession, the state gets the produced oil physically, rather than based on the royalties or taxes, etc. State could get the produced volume of the oil and assign the state oil companies to sell and the profit from the produced oil. But in production sharing, state gets lower taxes than the concession agreement, because since that state oil company gets produced extracted oil, the taxes will be lower than in the concession regime. Another type of the contract, which also very popular, it's a risk service contracts. It's was developed in Iran. The main purpose of the service agreement is similar in other service agreements, which use it in other different fields. It means that, for example, subsoil use right will be handed to the national oil companies, and the national oil company will hire the international oil company for help to produce oil. Then after the producing oil, just national oil company reimburse the money, the service fee, but the whole ownership of the for produced oil is belong to the national oil company. It's a difference in ownership, right? For example, in concession production sharing agreement, the ownership right, transferred to the international oil company. In service contract, the ownership right, still remains on state national company. Then state national company just reimburses body as a service fee for the oil company. It is risk service type of contract. Also, there is a type of other kind of contract. It's a joint venture contracts based on concession agreements. Could be as well in different jurisdictions. For example, mostly used in now in Middle East, which GV, joint venture between the national oil companies and the international oil companies starts a GV, creates GV, but this GV based on the concession agreement, which we already discussed. Then they just share their profit based on the joint venture agreement. Who gets what kind of volume of the oil from according to the corporate structure, according to the percentage in a joint venture. Despite that, there are different types of petroleum contracts, standard petroleum contracts around the world. There are specific, very common provisions, general provisions, which applicable to all contracts. The first is ownership. As I mentioned, ownership is could be different. Like in concession agreement, ownership belongs to oil companies, because ownership in the subsoil, under the subsoil, belongs to the state. After the producing the oil from the wells, it transfers to the oil company, and the oil company just pays the taxes, other kinds of payments to state. In production sharing agreement, ownership right, divided in a division point. We see distribution point. We call it who produced oil ownership belongs to state, but in a distribution point, it separates the oil companies, gets their own oil. Therefore, the transfer of ownership right, the state gets their own oil. There is a bit difference in risk service contract, for example. The ownership belongs to state national oil company normally. Of course, the duration of contract normally it is a 20 to 25 years. We have now contracts 40 years. Why is the contract duration is so long? Because every oil project is a huge cost intensive project, because it's not actually easy just producing the oil. You have to, it's a high cost intensive because have to drill the wells, have to drill the wells, have to construct the construction fields, infrastructure, etc., etc. It is like main. It affects on the duration of the contract for reimbursement of the costs. There are in contracts usually there are like very complex formula or payment structure used by economists for division of the oil. It depends on the calculation of the profit. For example, usually use the NPV method or IRR method, internal rate of return, net cash flow, different types of calculations is used in contracts. Then it's like a must-have provision in contracts. Usually, return obligation to return the field or part of the field. For example, let's say oil company starts exploring the oil in the territory. If the oil company finds the oil from, for example, in south part of the territory, but in north part was not successful, and the oil company has to return this north part to the state, shall not keep this territory until end of the contract term. The oil company has to return part of the territory to state, return back. It is also the kind of condition in petroleum contracts. Then the payments, bonuses, royalties, or other production sharing, as I mentioned, it depends on the contract by contract. Some contracts very profitable oil fields, it could be much higher, like payments, taxes, royalties, or some part of the some contracts it could be lower the level of the payment bonuses. Taxation, of course, taxes, and it depends on the contract by contract. Then the main like provision which very specific to international petroleum contracts is the stability of the contract. I will discuss stabilization provisions in more detail now, a bit in a few slides. Then the main provision is the applicable law clause, which law is applicable to petroleum contracts. As I said, this standard contracts, but applicable law could be, for example, international law, or could be national domestic law, could be English law. It depends on the contract by contract. Here is like common features of the contracts for standard contract. It like specifies the exploration period, the application of the oil companies, the obligations of the state, of course, the economic side of the project, environmental issues, transportation issues, dispute resolution mechanisms, and there are a number of like provisions which included in petroleum contracts. You know, for example, in production sharing contracts, when state participates directly in the producing oil field. For example, in production sharing agreement, states participates like in approval of the annual budget, approval of the like 5-year long-term budget, and there's in operation of the project, you know, like for approval of the costs, approval of the you know, each budget item, etc. Transportation, also state participates in auditing, you know, after the year, state audits the oil company under the contract for fair distribution of the profits, you know, for fair division of the profit for the economic balance purposes. This is the common features. As I mentioned, there's types of contracts and there's different specific provisions that are different for these contracts. Ownership term, risk sharing, and the main obligations could be are different for each type of the contract. And in order not to forget the main point, usually, you know, how these petroleum contracts are signed or awarded. Normally, states use two options for signing this contract. First is a competitive bid. It could be auction or sealed bid for between the oil companies. The second could be the like direct negotiations or award with the oil companies. Under the competitive bid, of course, that state invites oil companies around the world, says that I have this oil field. I invite you to invest to this oil field, and we will now organize a competitive bid. Which oil company propose more acceptable payment or bonus to the state. It is like mostly based on the competitive bid, which oil companies proposes most acceptable payment or bonus and conditions. The state, awards the contract, signs the contract with this oil company in a competitive bid. Also could be direct negotiations. Some states, for example, allow under the national legislation allows this direct awarding the contract. For example, in Kazakhstan, we have a direct negotiations with international oil companies and awarding the contract. And of course, state mostly puts forward some requirements to oil companies. It includes like saying that oil companies have the financial, technical, and like capability, environmental, sensitive, obligations. Of course, it's legal obligations on each of them. Just for your understanding, I would like to focus on to show you some contract provisions for your understanding. For example, oil contracts like specifies certain conditions. Like it's a period of exploration period, like 3 years, 6 years, and there's a development period, production period, like 20 years, 25 years, like duration. For example, I can show you, I'm just showing you some examples from different parts of the world, like Azerbaijan and from the Caspian Sea region, or Cyprus, it's different jurisdictions. There is also like for example, some specific provisions regarding the discovery of oil and the recognition of the discovery and the commerciality of the oil field. Some specific provisions of the oil contracts. It's a normal terms like for extension of the contract, etc. It's like examples when the oil companies pays amount of bonuses, the taxes, etc. It is some examples, for example, about this profit sharing and the cost recovery profits. What is the like percentage of division between the for cost oil and the for profit oil? This is a second part of this lecture, which I said regarding the comparative different types of the petroleum contract and the specific features of these contracts. And we have now Rosmalinda, if you don't mind, we have another 30 minutes.
Yes, but would you
Okay.
like to
Okay, I will now. Okay, I will now around 15 minutes. I will now try to finish the dispute part. Is the third part of the today's lecture.
Okay.
For then I will remain that 15 minutes for questions.
For answer, yes, please, sir.
Since that oil project is very like huge, very capital intensive, requires a lot of money. You know, there are, of course, a very high level disputes between the states and the oil companies. What actually was happened, you know, oil companies initially, like from the signing of these contracts, tries to get protection, yes, maximum protection from the actions of the state, from like expropriation, from nationalization, or etc. That's why they try to include the provision, kind of the governing law clause. Governing law clause, it like depends on the contract by contract. For example, in like common provisions, I would like to show you in petroleum contracts. For example, governing law clause in Libya concession agreements. You can see that in the slide, the concession shall be governed by and interpreted in accordance with principles of the law of Libya. It's a national law, yes, domestic law, common to the principles of international law. In the absence of such common principles, then
by in accordance with the general principles of law, including such as those principles as have been applied by international tribunals. It's a very complex provision, which included in a concession agreement. It is a kind of, governing law is mostly like a protection clause for investors, for oil companies, because for them is like a national legislation, domestic law does not give us protection. That's why they try to include like link this governing law to international law to have a more protection for their investment, for their money. For example, the Azerbaijan PSA, you can see that the governing law clause. This contract shall be governed and interpreted in accordance with the principles of the Azerbaijan law in the English law, like a mixing, to the extent that no common principles exist in relation to any matter in accordance with the principles of the common law of the Alberta, Canada. There is a like mixing the different laws in contract. It is actually very difficult in dispute resolution, during the interpretation of the contract, because in practice, many difficulties, in interpretation of these contracts. You have to lawyer, have to know the national law, how to interpret this clause, this contract. Also to know the English law, the Canadian law, and the international law, general principles of international law, and mix all of them and interpret the contract. That's why there are, always disputes between the states and the oil companies. Also, of course, most of the petroleum contracts includes the arbitration clause rather than domestic court, because for them is international arbitration is more comfortable to have in case of dispute to have a case on an independent arbitration platform rather than in domestic courts. For example, in practice, usually we have two parts of dispute resolution mechanism in petroleum contracts. The first is international arbitration, which disputes arising from the contract subject to the international arbitration centers. But regarding this disputes arising from the legislation, subject to the local courts of the state, this is like a two division. Usually, petroleum contracts use different arbitration centers. Since it's a commercial contract between the state and the oil companies, and subject to the domestic legislation, it is used, for example, London Court of International Arbitration or ICC, like International Chamber of Commerce in Stockholm, or UNCITRAL rules under the ad hoc arbitration, different types of the international arbitration centers. There are also the examples of some arbitration clauses in petroleum contracts. And in international petroleum contracts, there is another mechanism for dispute resolution is expert determination, we call it. It is, for example, since that in oil fields, there are many disputes. There could be the technical disputes, technical matters like, for example, drilling the wells, construction of some infrastructure, approval of the budget, etc. It's a very narrow technical engineering issues or something. In that case, lawyers, for example, the arbitrators, could not deal with this kind of very technical issues. That's why in contracts could be the expert determination. Expert determination means that on technical part of the disputes, parties could refer to the expert, and the expert make a decision on this. And not like lawyers, but subject matter expert. It could be like finance person, it could be like technical engineer person, could be like as a mediator. Will listen the state's position, listen the oil company's position, and then make a decision. It is like an expert determination. It's a very common dispute resolution mechanism used in petroleum contracts. In practice, we also usually use this expert determination from my practice. Also, the one more important, very important point is stabilization clauses, which very specific to petroleum contracts. Oil fields producing the petroleum is very capital intensive. That's why investors would like to get protection from the state's actions. Since that you will sign the contract, you will fix this payments, taxes, and the amount of the bonuses, etc. And the oil companies, try to fix these conditions until end of the duration of the contract. It means that contract will be stabilized until the end of the duration. In practice, there are 4 types of stabilization clause. The first is a freezing clause. Freezing, it means that petroleum contract terms and the conditions will be frozen, until the end of duration. And the state unilaterally cannot change this contract. Or legislation, for example, after the signing of the contract, legislation will be changed, but these new changes could not affect to the contract. It's like a freezing clause. And the prohibition on unilateral changes, it is a kind of a bit softer than the freezing clause, which will not allow the state to change the contract by themselves. One more is a rebalancing of economic benefits clause, also is very important. For example, saying that since that oil fields generate huge amount of money, profit for parties, there are always disputes between the states, state and the oil companies. That's why they include kind of economic balance clause in the contract, saying that if there is a harm to one part of the party, for example, for oil companies, they have to sit into a negotiation table and discuss how to balance the economic benefits of the contract. Also, the fourth type of the stabilization clause, the allocation of burden. Some cases, parties could agree that the burden could be allocated to one of the parties, to states or oil companies. This kind of stabilization mechanisms. There are very popular disputes, Texaco against Libya, Amin oil against Kuwait, it's a very famous family disputes regarding these stabilization clauses. For example, from my experience, I participated in a number of arbitration disputes and the expert determination disputes. Recently, we 2020, for example, completed settled one dispute with oil companies against Shell, Chevron, and Eni for 1.9 billion settlement agreement after the 6 years arbitration dispute. It was a huge dispute, and now I'm also involved in two main arbitration for the around 20 billion arbitration dispute against oil companies, Chevron against Shell, ExxonMobil, Total, any oil companies under the production sharing agreement. I have done from my side about these main points, and I'm ready to answer to your questions. The first question I got from the Cheryl Yazwar. They asked the question about this dispute settlement regarding this arbitration. The question is, do you ever experience the obstacles in implementing the result of arbitration decision in a country? Is it from the parties themselves or from the institution in a country? It's a very good question. Thank you very much. The point is, yes, all of the most of the international petroleum contracts include the arbitration clause. Arbitration clause mostly, under the UNCITRAL rules, could be ad hoc arbitration or institutional arbitration. For example, the ICC or Permanent Court of Arbitration or LCI, London Court of Arbitration. It depends on. Usually, since that parties already signed the contract, they in the contract they have an obligation, to execute the decision of the arbitral tribunal. It's like a must-have obligation. Since that, usually in contracts, petroleum contracts, there is a specific language saying that the arbitration decision will be final decision and they will not subject to the appeal. And the parties have to execute this decision. From my experience, we did not experience the problems or obstacles with the implementation of the decision, because since that usually parties is in international petroleum contracts is parties for long-term contracts, for 20, 30 or 50 years contracts. That's why parties tries to comply with arbitral tribunal decision because of the long-term work with the states, or state has to comply or oil companies has to comply with the arbitral decision. That's why it is in comparison with, for example, investment arbitration disputes, in commercial arbitration disputes under the petroleum contracts. Principle is also works between the parties. good faith as we know, it's a general principles of law, the first. The second is most of the national legislations, domestic legislations also includes this good faith principle. That's why the parties to the contract have to comply with the arbitral decision in a good faith and execute the decision of the tribunal. There is no much problem with the execution. There could be a problem, for example, we have in practice a number of disputes with Nigeria. Nigeria had around 10 or 15 disputes with oil companies around the world in arbitration. But the problem was regarding the appeal of these decisions. You know, some of them, Nigeria did not agree with tribunal decision and appeal it in local courts. For example, like 2 weeks ago, if I'm not mistaken, was a decision in a London court regarding the execution of the tribunal decision, and the decision was overturned by the London court, saying that the arbitral decision was made based on the fraud facts. It could be, yes. The second question. Very interesting question was asked. Question is that have producer countries began to modify petroleum contract terms in response to climate change and the energy transition risks? It's a now very important agenda in light of the sustainable development which set by the United Nations. As we know, many states, countries accepted sustainable development goals, transition from traditional energy sources to renewable energy sources. There is, answering directly to your question, there are now like adaptation or modification of the petroleum contracts in light of this climate change, but there are strict requirements in national legislation regarding the protection of environment. You know, it has not affected directly in the petroleum contract terms, but it's affected on environmental requirements from the national legislation, like states trying to put forward more strict requirements on protection of environment, on emissions, you know, on the gas flaring, for example, very strict requirements, very high, you know, fines for the emissions for gas flaring, etc. But the contract terms is not much changed in between the states and the oil companies. Another question is you know, it's also very good questions. Thank you very much for your interest and asking these interesting questions. I would like to share my experience regarding your question. Since I'm a practicing lawyer in this disputes, usually to keep the long-term relationship with between oil companies and states, since that these oil companies are strategic investors in countries, states also would like to keep very long-term relationship. But in case of disputes, mostly states and the oil companies, try to negotiate the claim, dispute, rather than go to the arbitration. That's why at the beginning, state has to start in good faith negotiation with oil companies, saying that the conditions changed. We have these kind of the claims or problems. We need to discuss with you, with the oil companies, and sit into the negotiation table, trying to good faith conduct the good faith negotiation. If negotiation are not successful, state could say oil companies in order to put forward their claim, saying that we'll use this independent arbitration mechanism, try to solve this dispute in arbitration, but it does not mean that we'll go to the end of this arbitration and have a decision. We are ready to negotiate during the arbitration process, and when the arbitration starts, but state always stays open to negotiations. And most of the disputes in arbitration could be also settled without the decision of the tribunal. It depends on the parties, it depends on the dispute. Mostly to keep very long-term negotiations, it is a preferable method is a negotiation, even after the arbitration dispute, parties has to, make a parallel negotiations with the arbitration process. It helps to keep the long-term, negotiations, long-term relationships between states and oil companies. I think that questions, I answered the 3 questions in the chat. If you have any other questions, please let me know.
Morning, sir. May I ask a question?
Sure.
Okay. First of all, please let me introduce myself. My name is Liza. I'm a law student at Faculty of Law Universitas Sumatera Utara. Your presentation is very insightful. I got a lot of information about the topic I have not heard before, and probably there is a lot of single word that I have no idea, but I put my attention for petroleum company, as you mentioned before. There are several biggest company, for example, British Petroleum and from UK and Mobil Oil from US, if I'm not wrong. So I have found that Indonesian government has assigned with British Petroleum. There is a several contract, for example, production sharing contract and about the liquefied natural gas project contract. And I have found that British Petroleum is threatened with a penalty from the Indonesian government worth 700 million US dollar. It's a big number, and the penalty was a result of delays of the project in one of the contract. So I would like to raise a questions about what if you were a lawyer? What if you were a lawyer for British Petroleum? What would you do to get a good deal or a good negotiations? So you don't need to pay as much as our government mentioned before. Because I think that the fundamental skill that you should have if you want to involve in dispute resolution institution, you need to have a good negotiation skill. So I would like to raise a question about what if you were a lawyer of British Petroleum? That's my questions. Thank you so much, Mr. Bagdat. Okay. Thank you.
Thank you very much. Very good question from practice. You know, it's a since that oil projects is a capital intensive, requires a significant of money from the oil company side. Or, there are always, you know, very huge disputes between the states and the oil companies. And your example is kind of this dispute. Usually, you know, oil companies such like BP or ExxonMobil hire like very reputable, very powerful law firms like disputes lawyers from United States or United Kingdom, which like a dispute could have a dispute in mostly in arbitration disputes. But in your case, I would say always has to start from negotiation. You know, try to negotiate with state as a lawyer from the BP side. Come to the state body saying that, for example, in your case, if there was like a fine from the state side, saying that to understand the like specifics of this payment, like a fine, what is the problem, and try to understand the issue. Then try to negotiate with the state bodies before going to the court or before going to the appeal. You know, try to solve this issue with the state bodies to keep the long-term relationship with the state. Then not to be so aggressive, you know, in case of BP, shall not that oil companies should not be so aggressive in states, in host states, because you know, as I explained it from historically, it was a changing, like a shifting balance, you know, always between the state and the oil companies. Since that state is owner of this oil, state tries to keep more power over the natural resources, over the oil. That's why oil companies always should to respect the right of the state, right to like save the environment, for example, right to have a benefit, and they try to balance the relationship, and they try to be more open, and in good faith negotiations try to negotiate first with the state bodies. But further, if the negotiations are not successful and the parties, for example, oil companies, exhausted all of the like available mechanisms to solve this dispute through negotiation, then in that case, jet oil companies would, you know, use arbitration or local court to solve the dispute in an independent platform.
Thank you, Mr. Bagdat. I think Our time is up, it's more than 10 o'clock. Would you like to have a closing statement before we will continue for the next week, our class?
No, thank you very much. It was a great pleasure to have this presentation, guest lecture with very knowledgeable students. I hope that this lecture was insightful, was informative, and was helpful for your understanding. If you have any questions, feel free to ask me by email. You can get my email from Rosmalinda and ask any questions regarding this subject matter. Thank you very much.
Thank you very much, Mr. Bagdat. Thank you for all students who are coming in this class and who are participating in the online Zoom. See you next week at 7:30. I think it is still okay, but for 7:30 next week.
Yes, I can do it. Thank you.
Okay, thank you very much. See you all and bye-bye. I have to close this.
Thank you very much. Bye.
Thank you, sir.
Okay, for all class, ketemu minggu depan ya. Saya akan tutup meeting.